Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Hey, Jim Potts back on the air. Well, that last show got a lot of emails from a lot of different people with a lot of different opinions about what we were talking about with the North Carolina governor, et cetera, et cetera, et cetera. Some of it was very positive and supportive of some of the things that I said. Some of it was not so positive in terms of people's emotions again, and the people out there that do not believe that people should be living the lifestyles that they're living. But that's just the way that it goes. And like I said, hey, we're going to have to live with it. So for those of you that, that are still having issues with it, hopefully in time, you'll see the light, as they say. All right, moving on. Let's talk about San Francisco, California. Well, San Francisco has a tendency to pass a lot of different legislation. And in my opinion, a lot of those legislators out of San Francisco are introducing a lot of the laws into the California system. Jerry Brown was in that area for the longest time, and I still think that they're working hand in hand, because now is what's going on is that San Francisco has now passed a fully paid parental leave ordinance. So in the city of San Francisco, a fully paid parental leave ordinance. Now let me explain what that is before I start my usual ranting and raving about how ridiculous some of this stuff is and how it impacts employers. They actually became the first city in the nation to pass this ordinance, which requires employers to provide paid parental leave to employees. Now, just to be clear, the ordinance does not require employers to provide 100% of the employee's pay, but rather requires employers to bridge the gap between the employee's pay, regular compensation, and the wage replacement benefit the employee receives from the state unemployment insurance office, which is the Employment Development Department of California, under the state's paid family leave program. So let me explain what that is. California, a number of years ago, paid. So let's just call it FMLA. Although in California we have what we call CFR, California Family Rights Act. So years ago, I think it was back in 2008, all of the employers in California started taking out 0.08% out of everybody's wages and taking that money and putting it into a fund. So if that person ever leaves under a medical leave of absence, then they would be able to collect money for a 6-week period of time. Now, the amount that they get to collect is based upon what their wages are. So I think the minimum amount was $50 a week, and the maximum, I think it was like $750 a week that a person could collect for that 6-week time under the FMLA. Although the FMLA time period is 12 weeks, they're allowed to collect for 6 weeks of that. But in all fairness, that's money the employee is paying in, the same way that they're paying in for state disability insurance, called SDI, on your pay stub, if you want to take a look at that. So now is what San Francisco is saying, is that amount that I just told you about, between the $50 or up to $750, their ordinance is now going to require the employer to pay the difference between that amount and what their normal salary is. Now, come on. I mean, how in the world do you expect an employer to pay an employee? And those benefits really didn't pay that much. Like I said, I think it was like 55% that they would be able to collect before. But how do you expect the employers to pay a half of the person's salary for 6 weeks, even though they're not going to be there? Again, this is San Francisco. My concern is a lot of these laws that come out of San Francisco end up ending up in Sacramento, and now all of a sudden in California. Some of these things can impact California law if these legislators say, oh, I think that's a great idea. This is what they call a blue state. I don't mean to get into politics, but they're very liberal up there in Sacramento, and this is clearly one of those situations. But again, they're not understanding the plight of employers financially. Everybody thinks that just because you're an employer that you're filthy rich and they can afford all of these things. That's not true. And these things are going to have an impact that's going to work in the reverse, because if they can't afford to be able to do this, they're going to reduce their staffs. Now people are going to be out looking for work. So to me, something like this is really kind of counterproductive. Now, this new law actually is going to require the employers to pay the remaining, it is 55%. The employer is going to have to pay the remaining 45% of the employee's wages for up to 6 weeks when the employee, whether it's the mother or the father, takes leave to bond with a newborn baby or a newly adopted baby or a foster child. So those are the requirements for why a person could be out under the FMLA or a serious health condition. Now, listen to this. This new law is going to take effect on January 1st of 2017. For employers with 50 or more employees is what the ordinance states. 50 or more employees, which is the requirement for an employer to be an FMLA or a CFR qualified employer. Now, employers with 20 or more employees will be required to comply beginning July 1st. So just simply 6 months, 7 months later, the employer is going to, with 20 or more employees, are also going to have to do the same thing. Now think about that. You've got an employer that's only got 5 employees, maybe 4 employees, and somebody goes out on a leave of absence, and they're going to have to pay just about half of that person's compensation while that person is out. I mean, you're talking some serious money for a small employer, because you already know that they have to keep their job open. Some employers, while somebody's out for 12 weeks, will turn around and hire somebody else so that they can still get the job done. Now, financially, they're not going to be able to do that, which is going to stress out some of the other people that are still working there, because they're going to have to pick up the slack for the person that's not there. Now, employees will be covered by the new law and entitled to the supplemental wage replacements for those, one, who have been employed for at least 90 days prior to the start of the leave. Number 2, who work at least 8 hours per day for the employer in San Francisco, and 40% of whose total weekly hours are worked in San Francisco. And 3, who is eligible to receive paid family leave under the state program for the purposes of bonding with a new child. Now look, first of all, ordinarily, in order for you to be qualified to take the leave, you had to have worked 1,250 hours over the last 12 months. Now, to me, is what they're saying here is that now they only have to work 90 days in order to get paid. So there's some serious implications behind this. There really are. Then is what they're also trying to do is July 1st. I'm sorry. So I gave you that. Now I want you to hear this. Now, some local newspapers up there are reporting that the Board of Supervisors also agreed to additional amendments that would make the ordinance applicable to employers with 35 or more employees July 1st, 2017, and to employers with 20 or more employees effective, actually they're saying July 1st of 2018, and which would make the benefit available only to employees that have worked for the employer at least 180 days instead of the 90 days. So it looks like they're trying to do some concessions as well. But the realities are any one of those programs that they're indicating, or time frames, or the size of the employer, can create a problem for small businesses. Now, for the larger companies, yeah, I get it. Larger companies, more money, but the larger companies, I would think, could afford a lot more than a smaller employer. You got 80% of employers out there, whether it's California or nationally, I think the rank is like 80% of the businesses out there are the smaller employer. And I'll just focus on California for a second and just say, all this overregulation in California and the things that they're doing, you're going to drive businesses out. So California legislators, I hope somebody out there is listening. You're going to continue to drive employers out of California with all of this nonsense. I mean, they just can't afford it. Now, I'll tell you something else. I'm talking about what San Francisco just did. Now, there's also what they call SB 1166, SB 1166, Parental leave. This bill that's being introduced this year, it hasn't passed yet, would require all California employers with 5 or more employees to provide up to 12 weeks of unpaid leave to an employee for purposes of bonding with a new child, etc. The same requirements I just told you under the FMLA and CFR, which is California Family Rights Act. So now is what they're saying is that, you know what? Instead of it just applying to employers with 50 or more employees, this new law is saying that if you've got 5 or more employees, that smaller employer now has got to give this 12 weeks of unpaid leave. Now remember, it's not unpaid because that's unpaid by the employer, but going back to what's going on in San Francisco, as I just told you, what does that mean? That means in San Francisco, yes, they got to pay 6 weeks. Outside of San Francisco, the employer does not yet have to do that. But it's still creating a problem for the smaller employer to have 5 employees, 3 employees, and now they're going to qualify for the FMLA or for CFR with 5 or more employees. I'm just telling you that I don't know why it is that these individuals are doing this. They're just choking the life out of employers in California. I've got relatives that tell me, hey, you shouldn't complain. That's what help keeps you in business. Look, I'm all about fighting on behalf of employers. That's my main thing. But I also believe in a healthy work environment. Employers should treat their employees right, and all of that. So don't get me wrong on that note. But as what I am saying is that since employers are the ones that are keeping people, with food in their mouth and shelter and all the other things that they need to pay their bills, then stop choking the life out of them, California. Just stop choking the life out of employers, because that's exactly what you're doing. All right, with that last comment, it's time to close out this segment. Let me remind you that you can also hear us on Facebook and Listen Up, and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday between 9:45 and 11. Or you can reach us by email. Just go to listenup@jameswilliampottsllc.com. You can also call us, as I stated, at 855-4J-POTS or 855-457-6887. Okay, I'm Jim Potts. I will continue to fight the fight. Thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.